Part 2. You've read through this. Let's do a review. What is the difference between an easement, a pertinent, and an easement by necessity? Well, an easement by necessity is maybe where we, that's what we're trying to avoid, is basically an easement by necessity says we cannot have any landlocked property. You've got to have access. And an easement of pertinence just means your neighbor, for example, is letting you use their driveway. And then obviously if someone was servicing a utility of some sort or a well, that would be another type of easement as well. And that is one by prescription, which was the next question. An encroachment. Let's say you've got your neighbor's fence over on your side of the lot line. That's an encroachment example. And you've got so much time to get that corrected. Otherwise, by state law, it assumes that because it was continuous, that it was with your permission, and it becomes an easement by prescription. Police power. The definition of police power around real estate, again, is not the actual police. It is all the laws put into place to protect our citizens, preserve order, create safety, create health standards. It's occupancy limits, zoning regulations. It's building codes, for example. And then what is the process where the government can acquire privately owned property for public use? I think you're all guaranteed to have an eminent domain question. And then the word condemnation goes through eminent domain. So let's say we've got a 2-lane highway that the government decides to extend to 4 lanes. That means on each side of the highway, we've got to get all those individual landowners to agree to give us a little sliver so that we can widen the road. Well, let's say you've got 10 owners on one side and 10 owners on the other side. So 20 owners total that you need to get eminent domain agreements with to do this project, and one of them holds out. Well, as long as they're able to prove that they're not taking, which is the next definition question, that they're offering a fair price and reasonable compensation, they can go through the process of condemnation and take it, because we've got proof that the other 19 are willing to comply. So again, taking means that we've got to offer a fair price for it. We discussed this one a little bit in the last video. What is the process called when the government acquires land through a legal life estate? This is a sheet, and this is because they died with no will, no directive on what happens with their personal and real property, and they died with no heirs or next of kin or family. And a sheet, I remember this as, oh, sheet. I didn't have a plan, and so the state of Iowa took all my stuff, or the state cheats. By you having a lack of plan, the state cheats. 3 basic forms of property ownership is going to be severalty. This is one ownership, only one person. Co-ownership, which is going to probably be on the exam for you, either joint tenancy or tenants in common. And then the last one is going to be a trust or business organization, which means basically you can create an entity to own property, either as a trust or an LLC, for example. This next one I think is a really good option for you to make sure that you know. This is one that I know comes up a lot. What is this distinguishing feature of joint tenancy? And the answer is right of survivorship. There's simply one less owner. And another good way to look at that is what type of ownership would allow a surviving spouse to avoid the judicial system of probate, which validates someone's estate. Again, that would be joint tenancy because of this right of survivorship. The next question, unless married, can a tenant in common sell their share in a property without the permission of others? Yes, they can. If they're married, they cannot, but if they are unmarried, they can sell their shares only, not the entire property, but just their interest in it. In order to create joint tenancy, we didn't discuss this a lot, but in order to do it, we've got to have the acronym PIT. That means possession, interest, time, and title. If you and I are going to take joint tenancy, we've got to do it at the same, at the same time. It's got to happen on title at the same time that we take interest in possession. So that's PIT. What is the purpose of a trust? The purpose of a trust is to create this separate entity. You can do it while you're alive, or it can happen after you're deceased. But the idea is it allows someone to manage it for you on behalf of a third party that we call a beneficiary. This next question on here is, what's the difference between a condo, co-op, and timeshare? A condo and a co-op are very similar in design. They can be an apartment style where you've got 12 units on 3 stories, or 4 units on 3 stories, making it a 12-unit building. It's very common, or even what I would call row housing or townhome housing, where you've got a shared wall. It's very common, the style of architecture, and then you've got common areas such as elevators, hallways, green spaces, parking lots. They're very similar. The really distinct feature between a deed and a co-op is a condominium. You've got an actual deed, a general warranty or special warranty, whatever type of deed. A co-op, because it's like a corporation, you're actually going to own stock in it, and in exchange, you'll have a proprietary lease. And then a timeshare is basically co-ownership with multiple owners of the same unit, and you only have access to that unit for a specific period of time, probably each year. What are the 3 types of a legal description? Meets and bounds, the rectangular government survey system, or lot and block. Meets and bounds is going to use a point of beginning, sometimes referred to as a monument, to get it started, and it's going to give a description of the entire border and bring it back to that original point of beginning. The rectangular survey system is what creates those tiers and range lines every 6 miles apart. And where that intersects those 6 miles, you get townships, which are 36 square miles. Now, each square mile represents a section, which is the next question. Okay, and a section is 640 acres, and then each acre is 43,560 square feet. Now, if I've not mentioned this already, something that you might consider doing if you're going to the test center for the exam, I think 43,560 is a really easy number to introvert introvert the numbers in a time of maybe a little anxiety, or you're thinking about an exam. I don't know, maybe anxiety isn't the right word. To help you with your confidence around that. What a lot of students do is when they go to the test center and you check in with your 2 forms of ID, your certificate of completion, physically, not on your phone, but physically from this class, You check in at the test center. They're going to give you a scratch piece of paper and a number 2 pencil. Then when you sit down at the computer station, before you do anything else, write 640 and 43,560. That way you don't introvert the numbers or change them around in case you need it for the exam. Again, a section, 1 square mile, equals 640 acres, and each acre is 43,560 square feet. Voluntary and involuntary alienation refers to whether someone chose to get rid of their property or not. Voluntary alienation is only by gift or by sale during the owner's lifetime. By will, by foreclosure, by a sheet, by condemnation, those are all times that someone can lose their property that would be considered involuntary. Okay, and again, a title, the document that we use with that is a deed. A general warranty deed is what offers the highest level protection of any deed out there. It's the best. The reason it's the best is because it protects against title flaws or title imperfections, such as a lien, from the past, present, and the future. Okay, the seller is warranting that you're not going to have any problems with lien imperfections from things that they've done to the property in the past, present, or the future. The exact opposite of that would be a quitclaim deed, because it offers no warranty at all whatsoever. I always remember quitclaim deed as I quit you, because this is the type of deed that often gets used in a divorce when we're trying to get someone off title once the divorce is final, and that way we can get them off title to reflect what was probably in their divorce decree. Transfer taxes. This is a tax on transferring real estate. In Iowa, we call it a revenue stamp. And if it's figured at $1.60 per 1,000, we would take $250,000 divided by 1,000. That would get us 250 units. And then we multiply that by the $1.60 to get an answer of 400. What is the act of placing documents on public record? And then what's the priority? The act of placing things on public record is recording, and the priority of documents recorded is on a first come, first served basis. So the first in time for date is the priority. So if I buy a property and I take the deed to the recorder, and everyone knows now that I own that property, and then my lender is going to put a lien against it right away, right? As a security for me to repay that debt. Well, if I foreclose on the property, that priority of liens is going to determine who gets paid back first. And of course, the bank that lent me the money always wants to take and maintain first priority. The only exception to that is special assessments and property taxes. Those always jump to the front no matter what the date is, okay? So know that as a test question. You also might have another style that lists the type of lien and the date. And if any of those are property taxes or special assessments, it doesn't matter what the date listed on it is, it automatically becomes priority. Okay, and that really addresses this lien on June 30th versus November 17th. Can salespeople sell real estate without an employing broker? The answer is a hard no. Salespeople cannot work independently. They must have a managing broker. Procuring cause. This is an uninterrupted chain of event that results in a sale. And last but not least here, we've got how much commission does a selling agent make when they receive, probably should be 7% on a $250,000 house. No, when they receive 70% on a $250,000 house with a 6% commission. What I'm going to advise you to do on all of these, if you got a commission, is just go ahead and figure out what everyone's making. Because some of these test questions are a little long, and then you think they're talking about Agent Sally, how much money she's going to make. At the last minute, they want Agent Joe. So I would just figure out everyone, the broker and the agent on the seller side, that's the listing side, and then the broker and the agent on the buyer side, that's known as the selling side. And then if there's any referral fees they want you to calculate, then it's a lot easier to pinpoint what money that's coming out of. So it looks like we've got an overall commission at 6% multiplied by $250,000. We had an overall commission of $15,000. If the test question doesn't specify otherwise, I would say that that commission just needs to be divided in two, which would be $7,500 for the buyer's side and the seller's side, or the selling side and the listing side is the seller side. 70% of 7,500, you would put that in as 0.70 in your calculator, which is 5,250. And 60%, which you would put in your calculator as 0.60, so I've got a little discrepancy there, which would equal $4,500. We are on to National Question and Answer Part 3 in the next read and video.